at the International Language Academy of Canada, and returning back to Turkey, he founded Özdemir Law Firm in 2004. Later, he concentrated on German and Spanish and received the title of Sworn Translator in English. In 2007, he studied legal English at Ankara University, and during this period, he carried out studies on competition law. In 2008, Aykut Ozdemir completed the Criminal Procedure Law Training and the European Convention on Human Rights Practical Training organized by Ankara Bar Association and received training on subjects such as European Union law and European Court of Human Rights and its functioning in 2009. Özdemir, who passed exams opened by Turkish Patent Institute in 2009, received the title of Trademark and Patent Attorney. In 2010, after completing mediation training organized by the Turkish Patent Institute, he received the title of Mediator in the field of criminal law. Özdemir attended various more trainings like patentability of computer inventions, intellectual rights on names and signs, European patent procedures, and also took to applied competition law training organized by Competition Authority during this process. In 2015, Aykut Ozdemir attended mediation and legal dispute training organized by the Union of Turkish Bar Association and received the title of mediator in legal disputes by successfully passing the exam held by Ministry of Justice in 2016. In addition, he completed mediation specialization training in labor law, mediation specialization training in commercial law, and mediation specialization training in commerce law, and finally, mediation specialization training in insurance law and training in intellectual and industrial property rights law in 2024. So about his academic background, he holds master's degree in information technology law from Hacettepe University, and at the same time he continued his doctorate on English language literature in Ankara University and forensic sciences in Hacettepe University, which he started in 2015. So currently, Aykut Ozdemir provides consultancy services to his clients on contract law, labor law, protection of personal data, intellectual and industrial rights law, as well as other issues, and carries out mark registration procedures. So after learning about his rich background, now we can welcome him to the stage with your loud applauses.
Thank you for participation. Today the topic is trademark and startup law. Maybe it's got some focus on these issues because it is so close issues, especially for the next generation, for the students. Trademark is very huge case, very detailed case, but we can just summarize it in here. We can start like, what is trademark? Is there any one who creates trademark here or applied before trademark? No. So trademark can be word, symbol, or phrase, smell, color, anything. It's getting wider actually, this area, and it is always progressing. So it is easy to, if you create a trademark, you can produce something or you can give a service, then the people can separate it, your service or your goods from the another one. Let's say created a unique one and no one gonna record it similar or the same one. So it's gonna protect you in the business life. We can say like well-known trademarks start with Nike. When you see the Nike swoosh, there is a line. You know, everyone knows that. You can understand without any name. It is Nike. It is trusted. It is quality. So you can directly trust and separate it from the other brands. Exact Reebok, Adidas, or any other brands. This is like we can give this information for goods. There is also services. We can call Walmart, Uber, or the others as a service. These are not supply by goods. They are supplying services like transportation services, commercial services, or shopping services. These are also the trademark. As I mentioned before, trademark can be goods or services. Then we can use it for logo or brand or numbers, devices, or the goods, or also, as I told before, we can use it for services. Let's say there is a service mark, leak fixers. One plumber produce or plumber factory can produce it can produce a good and the name leak plumber. Also, he give the service. He can say that I'm giving this service as a leak plumbers, leak fixers. It is the service, another one. So we can say the service trademark is the under the trademark issue. Also, the service trademarks, we can give examples like Facebook, United Airlines, and American Express, this kind of things. You can see the differences between trademark and the service mark. Trademark for goods, service mark for services, sold by company or service supplying by company. We can use TM for trademark, SM for the service mark. Also, the huge difference about the classification. There are 45 classification. It is the global classification. You can go to USA, you can go to England, you can make it in Turkey, but all of them start from 1 to reach to 45. First 34 class is about the goods. You can produce something, even flower or the television or the wall or any other desk. You have to apply for in this first 34 class. If you are giving service, like you create something transportation service like Uber, you have to choose between 35 and 45. These are mentioned in Turkish Patent Institute website, even in English. Get more detail in there. Trade name is, by the way, is different. Many people get confused about this. Trade name is the name of your company. Let's say the ABC company. It is your, and it is trade name. While trade name is your company, it has to be like a personal company or LTD or joint venture stock company. These are has to be in your name of the company and register in the commercial department in Turkey. Apple, just only Apple is a trademark, but when you say Apple Inc., you are talking about the trade name. These are different. But of course, you have a chance that you can use your trade name as a trademark. Apple, if they want, they can record it Apple Inc. instead of Apple. But it has the problem in the future. If you go to change your name of the company or the type of the company, like go to joint stock company to the other company types, it will be problem for the registered trademark. So what we offer, if you find any idea, any word, any phrase, you have to record it just for this, not for the company name. It will protect you in the future for the possible dangers. This also, you can see the difference. Apple trade name is Apple Inc. and recorded in the American commercial system, and this one is trademark. Also, American patent industry, they recorded it Apple with a sign. Your trade name automatically not come as a trademark. You have to record it. You can record actually if you want separately, but as I told you before, you have to avoid this recording. Just record what you want, not put the company name. In Turkey, there is a source of the protection and the regulation. We have 6,769 Industrial Property Code. Turkish name is Sanayi Mülkiyet Kanunu. Maybe you heard about it. It is the, uh, you can say like 10 years, it's valid. Who may apply trademark? Some of maybe you are foreigners. Even you can apply for trademark in Turkey. Just the idea you need to apply. This can be natural person or your company, no problem. Also, I will mention in the future, the company, establish a company is so easy, Turkey, and there are many supports. So if you have an idea, just think about the apply your trademark in here and protect your idea for startup. First, you have to find a name, as you see, and you have to choose the area that you want to sell or you want to give service. I told you transportation, IT, other sites, other areas is open. It's very wide. It's also connected to your startup. Many trademark come with these ideas. Apple, Facebook, Instagram, the other social services or the goods. They start with just an idea. As I mentioned before, there's 45 classes. 34 of them is for goods. The rest of it for services. You have to check before apply. When you apply it, the Turkish Patent Institute starts search about the similarity. If you apply and there's similar or exactly the same trademark, you got rejection. Of course, you can appeal, but before apply any trademark, if you search more and if you get service like searching for resemblance, you can find the good and the unique name, and you will not have to deal with these issues like application, appeal, objection, or the answers. To go to courthouse, you can avoid this, and the duration will be shorter. You can directly apply Turkish Patent Institute on website. I will show you exactly later how you apply. And also you can apply from the outside of Turkey. There is Madrid system. If you record in your country the trademark and your country part of the Convention of Madrid, you can also use your trademark rights in the other company. But in Turkey, as a Turkish, you can make it by yourself, this trademark application. If you are outside of Turkey, you have to use trademark attorneys. We have another registry page for this trademark lawyers, attorneys. Not any lawyer can apply for trademarks. It needs another license, another regulation. This Madrid system, I told you, there's Madrid protocol and agreement. Who is part of this agreement of protocol, they can get benefit from this Madrid system. And if they recorded their own trademark in the country, they can use it in Turkey or any other countries. They are part of Madrid system. When you apply, I told you, examination starts. The Turkish Patent Institute, the examination officers start search resemblance. If they find it any problem, they are rejected. Of course, you can appeal it. If there is no rejection and everything is fine, they just send you notification to pay the registration fee. If you pay it in 2 months, you got your application registered. If they are refusal, you can object it in the related department. They will reconsider it, and they're going to make a decision. There is also another letter of consent. If similar or same trademark owner before apply from you, give you permission, you can apply for similar to my name, or you can apply same as my trademark. Also, you can get your registration with this letter of consent. This is like permission the superior trademark owner. Generally, it takes like one year your trademark application. After 1 year, if there's no appeal or rejection of appeals, objections, you got your trademark. You have to use your trademark after registration in 5 years. If you are not using your trademark 5 years, someone can come and get this trademark, and you have to prove that you use it for 5 years. So after registration, you give service, you are producing goods, but anyway, you have to use it. You use your trademark. This is just for prevention of the bad will applications. Many people try to get the trademarks, even they it's not belongs to them, belongs to the other well-known, even well-known trademarks. They are just making it for bargain issue. Try to sell the big companies their trademarks. As I told you before, there is a re-examination and evaluation department. They got the final decision. After this final decision, you can go to courthouse and you open your case. The courthouse will be the made final decision. All these stages after that, you got registration, and you got this registration and protection for 10 years. After 10 years, before this duration finish, 6 months, you have to renew it. What you're gonna do? Yeah, you are just gonna apply for the system and pay the extension fee, and it is finished. You got another 10 years protection. So it's long time. It's also protect you in a good manner. I told you there's the application procedure, procedural examination. If there is any refusal, there is appeal side. If there's no appeal, publish in the bulletin. Then the 2 months there's no objection. Then finally, you got your registration. But it is a little bit. Any case can be different in this time. So uh, you just track your application properly and got the professional help when you apply for trademark. I will show you the how we make it. It is my system. There is EPAT system. It is you are making online, by the way. In the past, like around 10 years ago, we are just fulfilling the papers, cutting the logos, and they send them by hand to the Turkish Patent Institute. But right now, it is like e-Devlet. It's also successful application in Turkey, by the way. It is like e-Devlet system. It's EPATs. When you enter this, you have to your ID number and the password. Then this is for trademark attorney page actually. In the first side, yeni başvuru, you start this application from here. There are like trades and service brands, guarantee mark or partnership brand. In guarantee trademark, the guarantee trademark is guarantee the all the related companies. This trademark is under my control. The share trademark is like more than one people or one person and one company share ownership together. You can choose also if there is just a word or just a shape and the word together, or voice, even move, even color, or 3D. It is progressing. I told you, maybe in the future we will see the others. First, before there was just the first three of it. You had these chances. There are classes in Turkish, of course, I have to show. You are choosing from here 45 classes. What you want to do is exactly you can find similar or the same thing in here. After that, you are entering your personal ID. Then there is a payment side. Depends on the how many class you are applied. You're going to see that like nearly 1,500 TED per this year. It's changing every year, sometimes twice a year. You're going to pay this money at first. After registration notice come to you, in 2 months, you have to pay for this year 5,000 TL nearly for registration complete. This is the summarize of what you apply. Then you're finished. This is also our the system we are getting notifications from the Turkish Patent Institute. So related topic is maybe the young people is attention this startup law. If you have an idea with a trademark, without trademark, just company, just a good or just a service, as Uber, I told you, start like this. Uh, just you need an idea, business idea. It can be anything. You know that every idea it come from the regular person, generally the who got this chance very well. Also, the country or the background or the knowledge is important. Of course, you have idea, but it is not finished. You cannot just start and finish this idea. You need legal side, commercial side, and the tax side, technical side, anything. So that's why startup law is so connected to commercial law, companies law, personal data protection law, labor law, tax law, many things. I didn't mention here, but I told you there are many other areas is related to this. In Turkey, you can start your company as a human side, sole human side, which is şahıs şirket in Turkey, or joint stock company or limited company or any other company side. For limited company, you have to put 10,000 TL at first for establishment, and also joint stock company for 50,000 TL. Then you can start your company here. Joint stock company at first is maybe seems more costly, but in the future, especially for the liability or the chances or the applications, it has some advantages. Also, you can change your company type. Maybe you are the personal company just for your own that I don't recommend it because all liabilities belongs to you. You can change, you can distribute this responsibility to change the company from person to LTD, LTD to a joint stock company. You can change anytime. What is important for startup? I told you at first the idea. Then, if you are more than one person, you have to make an agreement. Then you can determine in mutual rights, obligations, what is shareholders' responsibilities, also the conditions, what is the partnership, who is going to manage the company, who can share transfer in which conditions, and the responsibilities to each other or in front of the company. Also, for this legal process to protect your idea as trademark, patent, industrial design, or any other thing, you have to apply for your protection, your intellectual rights. It can protect you in the future or later stages. Also, you start with an idea, and your workers make design or find something. You have to mention all this information in the agreement. Then it also prevents possible conflict in the future. Also, you have tax obligations. You have to find a good tax consultant and a lawyer. It can help you in any stage for your startup company. Who can start up in Turkey? Local and foreign investors, companies or the persons, they can start with startup. Also, you need investors, angels, venture, or crowdfunding investors. You can say angel investors, they join you in the first time and they give you financial support. Venture capital, unlike skills, the later stages and the major amount they are putting in. And also crowdfunding is go to public and they got many people by some numerous types. And you can get this support from the people for your company. If you start with a startup in Turkey, you have many chance. If you have a good idea and if you tell them and explain them in a good way, you can get some support from COSGAP, VITAC, also got tax advantages, also tax support for angel investors. These are many good side of your startup in Turkey. What is popular in startup? Financial technology, electronic commerce, transportation, renewable energy, and the many other side is so popular. So you can come along with this one of these ideas. Also, another advantage by startup, you can get Turkish citizenship. Depends on your investment, depends on what you do, depends on your even your income, and they get real estate or something like that. Also, benefits. I told you various business sectors. Many ideas come with this startup. Startup ecosystem is growing, even not in Turkey, all the world. And the starting company in Turkey is really easy. Also, I mentioned before, there are support initiatives. First, you have to check that you are not prohibited from making the commercial activities in Turkey. Then also you have to find that if uh, you need any permission from any other company, any other department of the government, you have to search very carefully. And also, if you are using intellectual property or trademark, this kind of thing, you have to search not to start conflict with another one trademark or another one intellectual right. Finished here. I make it a little bit quick because I don't have so much time. So if you have any questions for startup or for trademark, you can feel free to ask. I can happy to reply. Thank you.
Ses kontrol.
Mr. Aykut, thank you for the presentation of today. But I have like a question about the estimation fees of this trademark procedure.
You mean the service fee for
Yeah,
trademark?
yeah.
Actually, it depends. Unlikely the lawyer side, because we have, as a lawyer, there is a mandatory uh, minimum price list. It's like a union of Turkish bars published every year. We cannot get any case or any business under this prices. But the trademark side, there is no minimum price list. Generally, the market determines price. So I can say that if there is one class of application, like around 6,000, 7,000 plus what it's gonna be added. So also this application fees. So totally like for starting around 11 or 12,000 you need it.
Okay, thank you. Thank you very
Thank
much.
you.
More questions, guys? Do you have any questions? Okay, if not, I will ask you to wait for a minute. So we are really thankful for Mr. Aykut Özdemir's valuable speech. So I'm inviting Business Administration Department Head Tuğrul Oğuzhan, Mr. To the stage to give him his certificate of appreciation.
Thank you.
Arkadaşlar hadi toplu fotoğrafa siz de gelin.
Our guest will be Mr. Kürşat Ünlüsoy. Currently, he is advisor to the Ministry of Commerce, and formerly he was president of Turkish Competition Authority. Kürşat Ünlüsoy earned his degree in public administration from the Faculty of Political Sciences at Ankara University in 1997. Following his graduation, he joined the Turkish Competition Authority in 1998 as an assistant expert. Over the years, he ascended through various positions, including competition expert, chief competition expert, department head, vice president, and ultimately chief advisor, serving there until March 2024, which is very recent. He positioned as an advisor at the Ministry of Commerce. In addition to his early education, Ünlüsoy pursued further studies abroad and obtained a master's degree in public policy from George Mason University in the United States, which he completed between 2005 and 2007. He is now advancing his academic career by working on his doctoral thesis in public economics and finance at Hacettepe University. So with your loud applauses, I welcome him to the stage. Please.
Thank you very much. Hi, everyone. First of all, I'd like to thank Professor Hasan for inviting me, and thanks for having me here. Let's begin with the competition law. I'd like to talk about basically the concept of competition and basic questions, the economic foundations of the competition law, and the brief history and enforcement, and then I will conclude my presentation. In the daily life, we use competition, but in technical terms, it means a little bit different. You know, the competition or contest between the football teams or basketball teams, we may call the rivalry. We use the competition term in this context. In the Turkish Language Institute Dictionary, the competition means contest and race between people pursuing the same goal. But in economic terms, competition is a little more about the market structure. The process of contest for the largest share in the market, which is carried out by the actors in the market with various price and non-price instruments. The Turkish competition law defines the competition as a race between undertakings in the goods and service markets that enables free economic decisions to be made. Why do we need competition law? We need competition law as, you know, in a football match or a basketball match, we need a referee. Competition law is like, it's an instrument like a referee. And what is the purpose of competition law? It depends on the jurisprudence in the US or in Europe, in the emerging markets like Turkey. Sometimes the law protect consumers, sometimes competition itself, or competitors. But the prominence, jurisprudence, we can say that competition law ultimately protects the consumer. Which competition law are we talking about? In Turkey, there are some different laws in the. One of them is the law that protects the unfair competition. Unfair competition is a little bit different from the competition law. So, and the consumer and competition protection law is different from the law on the protection of competition. We will talk about the Competition Act number 4054. Uh, as you may know, we may classify the economic systems mainly in three groups. There are central economies, market economies, and mixed economy. Actually, we see in the real life in the world the mixed economies, not purely the state-controlled economies or not purely the market economy. Oops. Yes. In the market economy, there's these are the main specific size of the market economies. There's a supply and demand balance that forms the price. The most important indicator in the price in the market economy. It's like Adam Smith saying in his famous invisible hand. The invisible hand means we cannot see, but the price regulates the economy. And also economic incentives matter. Players aim to maximize profit. The companies aims to maximize their profits in the market economy. There's effective allocation of resources, and it needs an environment. You must own. You should have a privilege to have private property. These are the main requirements, and the dynamic change environment. In perfect competition market, also there are some assumptions in the first is the utility and profit maximization. The companies or the people should act in a rational way, and you must have full information about the market, which is openness, and the nature of products is very important. There, uh, there must be similar or products in the market. The nature of firms is very important. The scale capacity must be similar or equal. And the supply and demand price formation, which means the atomicity, which means there are many players in the market. And the mobility, the cost exchange of factors in production is another assumption. And there should be a cost-free entry. It means there shouldn't be any barriers to enter the market. And the absence of externalities is another assumption. What are the consequences of the competition, our positive effects? We can get efficiency in resource allocation, and the other consequences, cost efficiency and the dynamic efficiency. And by this way, we can increase the social welfare by competition. Also, in the real life, there are some market failures. Perfect competition markets do not exist in the real life, as you may know. And because of this, the state or government tries to do what markets cannot. These are the types of market failure. The monopoly means the single producer in a market, one seller. The oligopoly, there's few producers or companies, maybe duopoly or triopoly. If there are two companies in a market, it means we can call duopoly, or three. If there are three companies in the market, we will call triopoly. Monopsone means single buyer in a market, and the oligopsone, the few buyers. What's a monopoly? Monopoly just basically one firm. If in a market there's one firm that produces one product, we will call that market monopolistic market. Monopoly can rise by legal regulations or by naturally. The monopoly cost to society is not so much the high prices. It's not only the high prices, but also it produces fewer products that could be produced in a competitive market. The cost of monopolies to society, the marginal cost, and this is technical, but I will tell it in a simple way. If marginal cost equals to price, it's the competitive price. If you charge above the marginal cost, charge price above the marginal cost, then there will be a transfer from consumers to firm, or in the other case, there will be a transfer to firm from consumers. If you want to increase the price, you have to cut supply. But what's in the triangle that you see in red? That's the part stolen from the society. This part is a reflection of inefficiency. What's a cartel? In competition law, or in the real world, you may heard cartel term, but in technical terms, in Adam Smith's book, he calls this famous saying, "People of the same trade seldom meet together, even for merriment or diversion, but the conversation ends in a conspiracy against the public or in some contrivance to raise prices." So when the companies come together or meet, it will eventually it will cause to raise prices. If there are 4 or 5 or 6 producers in a cement market, for example, they can come together and fix prices. We call this a cartel. What are the negative impacts? If the price is to rise, supply is production is cut. It causes loss of well-being, and there are negative effects on employment, and there's a misdirection of the resources in this case, and the cost of intermediate good increases by the cartel formation, and establishing and maintaining a cartel is costly. So it costs to society. And allowing inefficient firms to remain in the market. If you form a cartel, it means that the inefficient firms will remain in the market. The common types of the cartel, these are the restrictive practices in competition law. One of them is the price determination among companies. If you fix the prices, it means it means the price determination among competitors. Or you can share the markets geographically. As I said before, in a cement market, you can share the geographic areas. For example, in Ankara, there may be 3 or 4 cement firms. They can share the geographic locations. This is a restrictive practice which is forbidden in terms of competition law. Or other way, you can share customers. And the last one is about the bid rigging cases. You can share your tenders in an auction. Concentration means in competition law, there are some you can see merger regulation or merger and acquisition regulations. By acquiring a company in a market, a rival can reduce the number of their rivals in the market. So the competition authorities try to control the merger and acquisitions. And there are some also joint ventures. They are also another type of merger. What are the impacts? The positive impacts of the mergers, they can increase efficiency, they can cause technology development, but the negative impacts in terms of competition law, the monopolization can occur and it can increase the potential for market structure to limit competition. If you get big company, you can control the market. Let me talk about a brief history and enforcement of competition law. In the 19th century, in the US, cartel and trust formations caused the antitrust regulations, especially in the railroad and the energy sectors. The famous saying of Senator Sherman in the US Congress, it says that if the concentrated powers of this combination are entrusted to a single man, it's a kingly prerogative inconsistent with our form of government and should be subject to the strong resistance of the state and national authorities. If anything is wrong, this is wrong. If we will not endure a king as a political power, we should not endure a king over the production, transportation, and sale of any necessaries of life. Like to submit to an emperor, we should not submit to an autocrat of trade with power to prevent competition and fix the price of any commodity. In the US system, these are the main acts, main law. The Section 1 and Section 2 of the Sherman Act simply, the Section 1 collaboration means cartels in restaurant of trade between states are prohibited according to Section 1. And according to Section 2, monopolization and attempted to monopolization are prohibited. And also, in terms of enforcement, U.S. courts can impose the private law, and there are two regulatory authorities in the U.S. One of them is the Antitrust Division of Department of Justice, and the other one is Federal Trade Commission. When we look at the historical development in the EU, there are some treaties. Maybe you may know the Treaty of Rome. According to the Treaty of Rome, common market is the main objective. And there are some competition regulations similar to the Sherman Act provisions. The agreements, restricted agreements, and abuse of dominant positions and state aids regulated by these regulations. The Lisbon Treaty they renamed, according to this treaty, the Treaty of Rome renamed as Treaty on Functioning of the European Union. In the US STIM system, the anti-competitive agreements and decisions and concerted practices applied to undertakings. The scope of these provisions is limited to undertakings, which is Article 1. The 102 is also applied to enterprises, companies. These are the abuse of dominant position cases, monopoly cases, we can say. And the other one is dealing with the public enterprises and state aids. These are also a part of competition policy, but in the Europe, it is regulated differently because of the different objectives. What about merger and acquisitions? It's in the Europe, there's a European Commission is handling the cases, and the merger and acquisitions are there's a different regulation, merger regulation in the Europe. We can see merger and acquisitions. We cannot see here, but merger and acquisitions is another regulation of the European Commission. What about the case in Turkey? From until 1970s, there were some preparations at the Ministry of Industry and Trade. In the article, the relevant article of the Constitution of the Republic of Turkey, there's a provision here which states that the state shall take measures to ensure and improve the healthy and orderly functioning of money, capital goods, and services markets, shall prevent the monopolization and cartelization of the markets that may arise as a result of actual argument. And in 1994, the protection of the Turkish competition law came into force. But after 3 years, the competition board became active because the competition board in this period they issued some secondary legislation. They completed some secondary legislation, and then in 1997 it became active. In the Turkish competition law, there's some different parts. In the first part, we can see purpose, scope, definitions. And in the second part, it's very similar to the ones in the US and the Europe. Agreements, limiting competition are prohibited, and the abuse of dominant position is prohibited. There's and merger and acquisitions also are controlled. The other ones is about the powers of board, administrative fines, etc. Also, in the enforcement authority in Turkey is the Turkish Competition Authority. The TCA has public legal personality, and it has administrative and financial autonomy. And it's according to law, the TCA is independent in fulfilling its duties. The revenues of the TCA come from the payments to be made by 4/13,000 of the capitals of the all ownerships to be newly established with the status of incorporated and limited company. And that of the increased portion in case of capital increase. This is very technical, but it mainly means that the TCA get its revenues from a separate fund, not from the budget. The related ministry is the Minister of Trade. What are the powers of the Turkish Competition Authority? It can request information from the companies, from the other public authorities. It can make on-spot inspections by its case handlers. And there are also fines, procedural and the substantive fines, which are as a result of the infringements. And there's some leniency settlement and commitment tools. These are very new. It can use the structural and behavioral remedies and interim measures. This is, as a conclusion, competition is a sine qua non of a market economy. Some concepts stand out in competition law practice and maybe used separate from their meanings in other areas or in daily usage. The enforcement of competition rules protects and enhances social welfare, also consumer welfare. And monopolies and cartels lead to less production, less employment, higher prices, lower quality, and lower technology, misallocation of resources and waste, and briefly, they are harmful to society. Thanks for your attention. If you have questions, I'm glad to answer. Any questions?
Hello, sir. I have a question, and first of all, thank you for being here with us. I have a question about Turkish law. Do you know that Turkish law, even though allows students to create a market brand and companies for foreigners, but the problem, which it's confused, I think, the Turkish law doesn't allow managers to stay here even though they have companies, which is if they apply for residence permit, I mean, Kimlik, they get rejected, even though they have own business here. Could you please explain that issue? I know a person who did his trademark here in Turkey, and he applied for residence permit, but his Kimlik got rejected.
Okay, I understand. Actually, it's about the the Ministry of Interior deals with it. I don't have any information about the citizenship or other, if you have a company and you apply for a citizenship, what are the rules? I don't know. That's not my area. Sorry. Okay. Another question? And there's a guy over there in the yes.
There's one thing that I did not understand. Why do we need competition authority? Like, I understand, like, it's an institution kind of, but what is the actual purpose for this? The competition authority.
Okay. Competition authority is the regulatory authority. If you have, for example, a special sector, for example, energy sector or other telecom sector, you have some special authorities that regulates that market.
Okay.
But in competition, it all covers all the markets. And it's, the main rationale for having a competition authority is to regulate all the market in terms of competition law.
Okay.
You mean, why don't you have a other entity?
Yeah.
Yeah, I can understand. That's a choice. As I said, in the US, there are two authorities.
Yeah.
One of them is Antitrust Division, which belongs to the Department of Justice. One of them is Federal Trade Commission, which is a regulatory authority like Turkish Competition Authority.
Okay.
In the US, it is historical. It based on the historical, because in the old days, Federal Trade Commission, and also it's about all the system. If you have the cartels in the US is a criminal to make forming a cartel is a criminal offense. So if you have a criminal system, you should deal the competition issues by courts, not the administrative authorities.
Okay.
But in Turkey, the provisions in the act which prohibits the cartels or other restrictive practices, and it's not criminal system, so nothing to do with the courts. You can charge an administrative fine. Okay, so you should have an administrative authority. This may be a separate regulatory authority, or it can be an administrative authority under a special ministry. But if you, by saying preference, if you prefer an authority, if you want to deal with the issues with a separate financial autonomous authority, you should use you should establish an entity like competition authority. Makes sense?
Yes. Thank you so much.
You're welcome. Yes, there's a question over there.
Sir, thank you for your presentation.
You're welcome.
I will try to explain my question. Excuse me for my bad English. For example, there is a company. This company sell some electronical equipment, and they have some rights to open some branch offices in different states, different cities, or they can give franchisee to different people in the different cities. If the company say to the franchisee, you should this product, you should sell this product with these prices. You cannot sell under these prices. Is that a violation of competition?
Actually, yes. It's not a hardcore restriction, but it's that is resale price maintenance. We call in competition law. If the competition levels can be in vertical or the other. That's your case is vertical case. You have a supplier. There's a main company. He can only recommend the price, but he cannot enforce that price to its dealer.
But the company has the all right of the brand,
Okay.
his brand.
Okay.
If, they want to earn money and they have to save their images, their brand.
Okay.
They can have some rights to decide about price and the other trade conditions, I think.
In some cases, if it's a selective distribution, it's a franchise system, it may be. But in conventional dealerships, they cannot do this.
Okay. Thanks.
You're welcome. No question, I think. Thank you very much. Thank you for your patience. Okay.
We are thankful to Mr. Kürşat Ünlüsoy for his very informative speech. Right now, to give him his good of appreciation, our teacher, dear teacher, I stand to the stage. Guys, we invite you to the stage, please. For IT students, it is compulsory.